Qualified immunity is being fought by several groups because of a shot by a Baltimore County Sheriff's Office corporal that ricocheted and hit a 5-year-old boy. The situation was tense because the woman that resided there was suffering a mental health crisis, and there were around 30 police that got involved. Add into all of this is Royce Ruby shot pretty blindly through a wall to hit Corn Gaines, which led to her son being hit. Gaines was armed, which is why so many members of law enforcement got involved, but there does not seem to be any talk of mental health professionals being called in to try to and de-escalate the situation. This all led to a lawsuit that ended up with a court awarding the father of Gaines' son $32 million dollars because of what occurred. This was then overturned by the Maryland Supreme Court because of qualified immunity. It is now being appealed to the Supreme Court. Howdy, y'all. This is Paul, the Redneck Thinker. What we have here is a channel to communicate. I want you folks to be thinking by the time you leave my videos. Why? Because I'm tired of people talking via what other people tell them to think. So, watch my video and enjoy the chance to think for yourself. And down in my Substack down below, you can research it all. Okay, Here Be a Reason is an in-depth look at the case. During an August 2016 standoff with an armed woman at an apartment in Baltimore County, Maryland, a police officer fired his rifle through an interior wall into the kitchen. The bullet struck the woman, Corn Gaines, in the upper back, then ricocheted off the refrigerator, striking her 5-year-old son, Cody, in the cheek. The officer, Baltimore County Corporal Royce Ruby, later testified that he fired the headshot without a clear view of Gaines, saying he could only see her braids and the barrel of the shotgun through his rifle scope. He also said he could not see Cody, but knew that he was in the kitchen and that there's a possibility the boy would be hit by the bullet. A witness testified that Gaines, explaining his decision to take the shot, described himself as hot and frustrated. It was understandable that Ruby was hot. The police had cut off power to the apartment building, which was sweltering without air conditioning. Was also understandable that he was frustrated. At that point, the standoff, during which more than 30 officers surrounded the building, had dragged on for more than 6 hours. Police had told Gaines had a history of mental illness and that she had been off her medication, as the Maryland Supreme Court later noted. Officers testified that Miss Gaines acted erratically, sometimes negotiating with officers, at other times threatening them and cutting off contact. It is harder to fathom why Ruby decided to fire his rifle, even though he recognized that he was endangering a little boy and even though he was not facing an imminent threat of death or serious bodily injury. The Maryland Supreme Court accepted that Gaines may have raised her shotgun but was not aiming it directly towards officers. It nevertheless ruled that Ruby was entitled to qualified immunity, which shields police officers from federal civil rights claims, which most people know. Based on that conclusion, the court overturned $32 million in damages that the jury awarded Cody. The boy's father, Corey Cunningham, is now asking the U.S. Supreme Court to review the Maryland Supreme Court's decision. Obviously, unlawful conduct alone clearly establishes the law such that qualified immunity does not apply, his petition argues, citing Supreme Court precedents to that effect. Conduct that is so egregious and obviously unlawful as to shock the conscience necessarily forecloses qualified immunity. The Supreme Court, the Cato Institute notes, in a brief supporting Cunningham's petition, has held that some rights violations are sufficiently obvious to violate clearly established law even without factually similar precedent. It urges the justices to clarify that a court should not grant qualified immunity to a police officer who committed a conscious, shocking rights violation simply because it could find no prior decision involving nearly identical facts. In this case, Cato says it is self-evident that the officer's conscious, shocking conduct violated the right of Cody, an innocent bystander, to be from arbitrary state action. There's more to this case. And like I said, they're talking about him, that Corporal Ruby violated the 14th Amendment when he did this. So you can read all the rest of this, but this is the case so far. Now, I'm going to leave this up to you, my listeners, to decide what you think. If this if this corporal deserves qualified immunity or not. Seriously, it's up to you to decide that. I want you to know what your opinion is. I tell you folks that I want you to think, okay, well, here's the time. Make a decision. Do you think he deserves qualified immunity for his actions? Do you think that the shooting of this young boy deserves the 32 million, or that Ruby doesn't deserve to be punished for his actions? That's what this case is. I want to know people's opinions for the simple fact that we need to get to the point that we understand in our own conscience what this means. We don't need to be told what this means by other people. So, this has been Paul, the Redneck Thinker. Y'all have a good day now. Bye. Folks, I just want to say thank you for listening. I want to thank you for taking your time. I want to hear what your comments are about what you think on this topic, because your comments are what's important, not necessarily mine. I don't care if you're Republican, I don't care if you're conservative, I don't care if you're liberal, I don't care if you're Democrat. I want to hear your opinion on these topics. I want to thank you yet again for listening to my video. Like, subscribe, and all that other hoopla. This has been Paul, the Redneck Thinker. Y'all have a good day now. Bye.